Hey y'all, it's Adam Johnson with my brother Jonathan Johnson, both of the Johnson firm. All right, so we've talked about just generally the types of divorce. Now I want to talk about, okay, you filed for divorce.
Mhm.
What comes next? What are the different type, avenues? Where do the roads lead?
Sure. Law refers to that as the incidental issues, the incidental matters. Uh, the ones that we see most commonly are child custody, child support, spousal support, and community property partition.
Okay.
You can also have protective orders and things of that nature, but those are the main ones that we see.
When you say community property partition, are you talking about just dividing up the property?
Yeah, so Louisiana is a community property state. It doesn't matter whose name something's in. Assuming you don't have a prenuptial agreement, a matrimonial agreement, then whatever is accumulated during the marriage, acquired, debts, assets, it belongs 50% to each spouse. And we have to go through the process of determining what everything is, what the value is, and then dividing it and making sure everybody's piles are equal.
Okay. Let's
Big,
talk
big
about
part of that.
child custody.
Sure.
That's what seems to be a very heated issue and results a lot of times in, that's where the rubber meets the road, it seems like.
It's normally the most just place where there's as much conflict as anything.
Yeah.
It's extremely emotional. It's being decided right at the beginning of the case where these parties may have just split up. There could be all sorts of, emotions associated with just the marriage ending, and now they're being asked to put together a plan for your kids. By far, the best result is when two people going through this can sit down and go, okay, this is what's best for us. This works for our family going forward.
Okay.
It just doesn't happen very often.
Right.
So when they come to us, they're looking for advice of what factors into this. What
does factor
what's
into
the
it?
court look into? Well, everything. The the legal standard is the best interest of the child.
Which
It's
is
filed
broad.
with Louisiana Civil Code, and there's 13 factors, and those 13 factors basically cover everything.
Right.
So I tell people all the time in the area that we work in, there are a ton of plants. We see shift work all the time.
Yeah.
Okay, one side of the case or the other. So if I have two really good parents, all right, nobody's got any drug problems, there's no abuse, there's no concerns about anger or anything else like that, and we're talking about a custody plan, and somebody's a shift worker, the number one thing that's going to be talked about early on in the case is going to be that schedule.
Okay. What happens during a turnaround?
Yeah, well, it's not just turnaround. It's just, I work, 7 on and 7 off, but on my 7 off, I have to pick up some overtime and or I'm on a Canadian swing shift or whatever. There's all sorts of these things. So that becomes a big factor. But if there are substance abuse issues, if there has been abuse, if there are concerns about what the other person is doing, or what role they played historically with the kids,
Okay.
those things become prominent. So it's really impossible on the front end before we know anything about a case to say, well, this is what's going to decide your custody case.
Right.
We have to meet with you. We have to go through all of the details of your case, and we have to understand it to be able to say, all right, well, here's what is applicable to your case, and this is what we think we need to further investigate so that we can prove up your custody case.
It would seem like, too, if you're talking about 13 different factors, best interests of the child, this big, broad, consider everything standard, it's really important when you're talking about custody of your child to have a really good lawyer.
1,000%. And not to make those decisions without really good counsel.
Yeah, right.
So
Let me ask this question. When you have a lawyer that's willing to take a custody case to trial and has been through a number of custody, trials, does that make a difference on what you get on the front end when people know that about you? And are there lawyers who just actively just sort of like seek to avoid going to trial at all cost? And does that affect their representation? I know that seems like a loaded question, but
sure, but it's 100%, and it's not just in family court. It's in any walk of litigation. If the other side knows that the attorney on the other side, A, is not afraid to take cases to trial, B, is experienced at trial and has success at trial, then 100% they're going to be more inclined to negotiate reasonably throughout that case.
That's right.
So who you hire does matter.
They can determine what you think is reasonable based on what you've gotten in other cases, right?
Exactly right. And also just the experience with the court and the court process. We know all of the hearing officers. We know all of the judges. We know what they're going to award and what they're not in these situations because we've been through them a ton of times. So a lot of times when I meet with a client and they lay the situation out, I can tell them, hey, this is the range of what this hearing officer is going to recommend. And if we don't like that, we need to gear up and we need to file an appeal and we need to be prepared to try that case.
Just a more informed process.
Absolutely.
More options, not, I guess, just sort of not available because the lawyer just is afraid to go to trial or just doesn't know how to introduce evidence.
That's right. So, custody, joint, sole, those are the 2 types of custody. And then the schedule is really where the rubber meets the road.
You talking about the custody schedule?
Sure.
Okay.
The difference between joint and sole custody, people get this in their head and get confused about this all the time. Joint and sole custody is really a legal determination thing. So if I have sole custody and little Johnny turns 16 and he's driving around and he gets in an accident, okay, well, that person can sue me because I have sole custody.
Okay.
If I have joint custody, well, he can sue me and he can sue the mother.
Right.
Okay. It's a legal responsibility thing. It also impacts how much I have to communicate and involve the other side in decisions.
Okay.
So if I have sole custody, I still have to inform the other side that, hey, I'm moving the kid's school to a different school. Okay. They say, I don't want to do that. You say,
but you're informed.
I'm not communicating about it. I'm just informing you.
Yeah.
Okay. If I have joint custody, I'm domiciliary parent. I've got to say, hey, I would like to move the child's school to another school. What do you think about that? And you say, I don't think that's a good idea. Okay. I vote yes. You vote no. As the domiciliary parent, I get the tie-breaking vote. So
you're talking about sole custody, joint custody, and then you talk about domiciliary.
Right.
Explain that.
So in sole custody, we don't have a domiciliary parent because that person is the domiciliary parent. In joint custody, we have to designate a domiciliary parent, and that person, generally speaking, is where the child's primary residence is.
Okay.
But not necessarily all the time. But that person has authority to cast that tie-breaking vote in the event the parents can't come to agreement. So if I'm domiciliary and there's a medical decision that has to be made that we don't agree on, I get to make that call.
Okay.
If there's a dispute over school, I get to make the call if we're at odds. So it's a decision-making, chain of command, so to speak.
Yeah, sure.
So people say that all the time. Well, I want sole custody, and when I get down to it, they're like, oh, well, no, I just really want to be domiciliary parent. And the reason that's important is because the other side, uninformed, when you say I want sole custody, they think, oh, that means I'm never going to see my kid.
Yeah, right.
And these people are they're saying one thing, a legal term, but they're communicating something completely different.
Right.
So once they understand everything, they may go, okay.
You got to have somebody that can explain to you all those different rules and keep you sort of fully informed so you don't just argue over nothing and run up attorney's fees.
Argue over nothing, run up attorney's fees, and also just inflame the situation.
Yeah, right.
Because
unnecessarily.
You're trying to keep emotion down where you can.
Yeah.
We
deal with that all the time, right? We talk to our clients all the time, but we're dealing with an attorney on the other side or a law office on the other side that never communicates with their client, and so
it's all between them or who they're hearing from and their friends or whatever.
Yeah, right.
So I mean, it's important to have the right information, but the schedule is what is really important in the custody situation. So even in a sole custody situation, you could have equal access between the parties.
Okay.
No one understands that.
Yeah, right.
Common people that aren't lawyers and involved in this process, they think sole custody. No, the other side has some sort of maybe no visitation or limited visitation or supervised. No, it could be 50-50 custody, but the other side has sole. That's rare, but it can exist. That schedule is normally what people are really concerned about.
Right.
When they're coming in and talking to me, that's what they're concerned about. And a custody case is about determining that legal custody, joint or sole, who's going to be the decision maker, have that tie-breaking vote in the joint custody situation, and then what's the schedule going to be? And that takes up a lot of time in these cases, and it takes a lot of attention. A lot of times, we can't get to that community property partition we talked about because everyone is primarily focused on what's going to happen with our kids next. The next thing that we talk about is child support. Child support is a math formula. We've shot a separate video talking about how that's calculated and computed. There's on our website, there's a child support calculator that is tied into Louisiana law that will give you a number if you put the inputs in correctly. We can run that number for you and tell you, hey, this is how much child support is going to be. And most of the time, we're within $2 or $3.
Okay.
It is a formula. The other thing that comes up is spousal support in these cases, and there's 2 types of that. There's interim and there's final.
All right. What's the difference?
Interim is while the divorce is pending and up to 6 months past.
Okay.
The big difference here is lifestyle. Interim has nothing to do with fault. It is what was the lifestyle of the parties. One side says I'm in need. So let's say one spouse makes a lot less than the other spouse. That spouse comes forward, says I'm in need of support. They demonstrate that they made this much money and their lifestyle was they were spending this much money.
Right.
So they want the other spouse to make up that difference from their side of the equation.
Right. They're entitled to that?
The law says that if they can show they're in need and the other side has the ability to pay and the lifestyle of the marriage is consistent with that, then yes, they're entitled to that while the divorce is pending.
I hear those three things and I think a really good lawyer is going to get you the best situation in that circumstance, because those are all sound negotiable.
Vague terms.
Yeah, right.
Vague terms. It's not like child support where there's a math formula.
Right. And tell me this, because I like talking about your background. I think that your background gives you just such an advantage. The accounting background, having worked for the CPA, knowing numbers when most attorneys don't understand math. And you have a husband, let's say he's a doctor, just for example, makes a lot of money. His wife stayed at home and raised the kids. They're now getting divorced. It's not uncommon for people that make a lot of money, once they know that they're going to go through a divorce, to then try and start hiding from the former party how much money they made.
Sure.
Is that fair?
Absolutely.
Okay.
And there's all sorts of ways that they do that. If they're self-employed, then there's all sorts of business deductions that are run through. If they own rental properties, they're taking big amounts of depreciation. There are tons of things that my background in accounting specifically, and our familiarity with this process allows us to get in there, dissect. And if it's even too complicated, we employ professionals. We'll bring in a CPA to go through those documents. So the point is that these claims exist, and whether you're potentially at risk of paying it or you're the person that needs it, you need the right advice, and you need an attorney that knows the rules, and like we said earlier, isn't afraid of this process.
Right.
Because I mean, you wouldn't think this, but you know this from doing this in your area of practice. There's a bunch that aren't going to push the issue. They're not there. Even though this whole industry that we're in is built on kind of confrontation, the right of confrontation, there's a ton of people that don't want conflict.
Right.
So,
and don't realize by avoiding it that sometimes it's their clients that are losing out the worst.
Absolutely.
Yeah.
So we've got that interim spousal support, final spousal support. The difference is that it doesn't factor in lifestyle, and you have to be free from fault to even ask for it.
Okay.
So if you're free from fault, and we went over the fault in one of the other videos we shot, but if you are free from fault and you can't meet your necessities, okay, not lifestyle, so not the $8,000, $10,000, $12,000, $20,000, $100,000 we spent a month when we were married, depending on your income situation, but my basic necessities: food, clothing, shelter, transportation, things of that nature.
Yeah.
Normally, if somebody's making about $50,000 a year, they're not going to qualify for final periodic spousal support.
Okay.
We're talking about situations where
homemaker, breadwinner,
long marriage, very little employment by one spouse, or very minimal employment, and high income by the other.
And the idea is that was a choice that was made.
100%.
Okay.
And it's been going on so long that we can't allow one spouse to just be burdened. Another difference, a lot of people don't know this, is interim spousal support, we don't look at assets. We just look at incomes.
Okay.
Final spousal support, we look at assets. So if we've got a $2 million community property partition going and one spouse is going to get $1 million, even though they never worked during the marriage, they could not have a need because, hey, you're getting enough assets to have a steady stream of income. Maybe you're getting a part of a pension or something like that.
It sounds like it's super important to know, how to look at a balance sheet, what a tax return is,
profit and loss statements, all of those things, and to be able to get in the weeds with the numbers and know how the law applies the numbers.
Right, and not just put yourself in a situation where you're having to take the other lawyer who's opposed to use word for whatever the equation results to be.
Yeah, that's right. So, child custody, child support, spousal support, and community property partition. A little bit on community property partition. What's going to be prepared with our office is what's called a detailed descriptive list. It's a list of all of your assets and all of your debts, valuation on all of those. If we don't have valuations, if it's not a statement for a 401k or something like that, then we have to get appraisals. That process can be very complicated. Sometimes it's fairly simple. We've got our home with a mortgage. We have 2 cars and they have debts on them. And we have a 401k and some movable assets.
Sure.
That's not going to take professional appraisers and experts to divide
Yeah,
that.
but you were in business together. The business was extremely successful. You're breaking that up, or one person's buying the other person
Sure.
out. That gets pretty complex.
Met with somebody recently. They had 4 different businesses.
Yeah.
Okay. All of them are going to have to be valued and divided. So, those are the things that are more complex. The divorce, like we talked about, one of the easiest things from a, just procedural standpoint in the law. It's all of these other things that are very, very complicated.
And it matters.
They're very, very fact specific, and they impact things that are incredibly important. Either your time with your kids,
Right.
how much of the community that you end up with, how much money you end up
And
with.
what I imagine is this. In simpler terms, what I imagine is this. What you don't want to be is one of those people that whenever they went through a divorce was super emotional, didn't hire competent counsel, and just said, okay, I'm just going to get whatever I get. I'm just going to be one of those people. What you don't want to be is the person that finishes the divorce, finishes the community property partition, and feels like they got worked over by the other side, right? Because there usually is sort of a dominant person in the relationship, it seems like. And so you just don't want to find yourself the victim. You want someone to stand up for your rights, do the work.
I say this all the time. Don't be a victim twice. Okay.
That's right.
You're a victim of the circumstances that you're going through. Whether you want the divorce or not, it's a difficult process.
That's right.
Okay. Don't be a victim of the divorce process itself, which is all of these things we're talking about. That's why it's important to come sit down and talk to us.
Yeah. Okay. Well, thanks for walking us through that. If it sounds complex, it's because it is, but we're trying to break it down for you and give you as much information as possible. So that's all for this one.
Yep. Appreciate it.